It is, it's interesting because you asked me earlier about my spiritual inclinations, and I said I don't really have any, and yet there are a number of fundamental values that, in all candor to you and to myself, Doug, I think really come down to a matter of faith. I don't think they are provable presumptions. I have a presumption in favor of the goodness of human beings. Why do I give them the benefit of the doubt? I have a presumption in favor of free choice and free will, even though I've read Robert Sapolsky and other scientists who argue that there is no such thing. And I have faith in individual human beings to ultimately do the right thing, even more than I do in government officials. And so bound up in that is this notion that we are autonomous individuals who have the opportunity and the responsibility to exercise our I call it freedom of choice, will, intent. And maybe that is a type of religious belief that you're reflecting the divine in each individual, right? The way the law deals with it is there are two concepts of intent. One under tort law, which is civil damages type law, the other under criminal law, where the government can punish you. The tort concept is less demanding, and that is you are held to have intended the foreseeable consequences of any act you undertake, even if you didn't specifically desire the particular outcome. Under criminal law, though, it's a higher standard. It's not just kind of a negligence standard. If you should have foreseen that this would be the consequence of your taking that act, you cannot be held criminally punishable unless you specifically desired that particular result. And in free speech cases, the court has insisted on this specific intent standard. They recently had a decision involving a true threat. The concept of true threat, the adjective used to distinguish threat from the way we use it more loosely in everyday speech. The Supreme Court in earlier cases had said the speaker means to instill a reasonable fear on the part of audience members the speaker addresses that they will be subject to harm. And the speaker, by the way, doesn't have to intend to carry out the harm, but has to intend to instill the fear. Once you have that fear, you're already going to be inhibited in your freedom of speech and your freedom of movement. And the Supreme Court recently had a decision in which the justices split at least 3 different ways about, well, exactly what concept of intent is enough here. And they came out with either the specific intent that you specifically desired that impact, or you acted recklessly. You deliberately ignored a substantial risk that your speech would have that impact. So both more demanding than the negligence standard.
Hard to prove. That's
hard
a very
prove.
hard intent
Yes.
standard to prove. And so you offered a beautiful, and I hated that question because it was so open-ended, but I knew it was good. The problem is you need somebody who can answer it well. Okay, which you just knocked out of the park, and I thank you for that. That's a priceless
This,
clip
by the
on
way, some of the litigation against Donald Trump in January 6th is coming down to this issue. In the speech that he gave to his supporters before they marched on the Capitol and stormed it.
Right.
Did he?
Right.
So the standard there is one category of speech that's unprotected, even if it is speech, is intentional incitement of imminent violent or lawless conduct that is likely to happen imminently. And I think the big debate is, did he intentionally incite those followers or not?
Yeah.
And judges have split on that so far.